On March 3, 2009, the U.S. Supreme Court heard arguments in the case brought by Hugh Caperton against the giant West Virginia coal mining company Massey Energy. Caperton is president of the now-defunct Harmon Mining Company. The central issue to be considered is whether a justice of the West Virginia Supreme Court should have disqualified himself from the case that Caperton had brought against Massey and which Massey had appealed. That state court judge, Justice Brent Benjamin, overturned the $50 million judgment that Caperton had won against Massey in the lower courts. But Caperton had insisted from the beginning that Justice Benjamin should have disqualified himself from the case because Benjamin owed his position on the court to the $3.5 million that Massey's chairman and CEO, Don Blankenship, had contributed to Benjamin's campaign and which helped Benjamin acquire his seat on the court. Representing Caperton is Theodore Olson, a former Solicitor General who has argued a number of important cases to the U.S. Supreme Court. In the following September 3, 2008 interview by Scott Finn of West Virginia Public Broadcasting, Olson explains why judges should disqualify themselves from cases in which they have an apparent conflict of interest.
You don't take every case that is pitched your way. What is it about this specific case that you think is so important and worthy of your time and attention?
Well, I do think that there's a very, very important legal question here, and it's one that hasn't been answered by the United States Supreme Court. The Supreme Court has said that every litigant is entitled to a justice system that is fair and evenly balanced and should not involve decision makers who are biased one way or the other or appear to be biased one way or the other. The issue is, under what circumstances are those facts there that should cause a judge to take himself out of the case? And I think the record here is quite strong that the particular justice we're talking about, having been financed in substantial part by one of the litigants in this case, should have withdrawn from the case.
Now, one of the questions here, of course, is where to draw the line. At what point do contributions get to the point where it influences or has an appearance of an influence on a judge's decision-making?
Well, that's like a lot of questions in the law. If you think about things like cruel and unusual punishment or unreasonable search and seizure, it's very, very difficult to say that there is a bright line that you could draw that would solve every case. There isn't. Constitutional principles, equal protection of law, due process of law, and things of that nature, due process is the issue involved in this case, are very hard to determine with specificity. But when you have a candidate for judicial office who was substantially, materially sponsored by one of the litigants in a case, in this case $3 to $3.5 million were spent by one of the participants in this case to help elect this particular justice, it seems pretty obvious that most people would say, my goodness, that individual is either going to be beholden to the people that contributed to his campaign or he would be tempted to be. And that, I think, in most people's minds would create the appearance of bias.
What sort of standard would you hope that the Supreme Court would set if they took this case?
Well, I think that the court is going to say when there is a substantial basis for believing that an ordinary member of the judiciary might be influenced or might be tempted to be influenced, or ordinary persons looking at the situation would believe that they'd be tempted to be influenced, then in the interest of justice, that individual should withdraw from the case. And someone who doesn't have that disability could be appointed to replace that justice. There are mechanisms in most courts for appointing someone to replace a justice who withdraws from the case. In this situation, this actual case, one of the two of the justices previously withdrew from the case because of concerns about that, and they've been replaced for adjudicating this case. That could happen with this particular justice easily.
What do you think the chances are that the Supreme Court will take this case?
I never try to make those kind of predictions. I think, as you and probably most of your listeners would know, the Supreme Court receives several thousand petitions every year and takes less than 100 cases. So it's always a bit of a long shot. On the other hand, this is an issue that the Supreme Court has dealt with before, generally speaking. It's an important consideration for the court to assure that our judicial systems are not only fair and balanced and free from bias, but that they appear to be to the ordinary citizen. We want our citizens to believe in our courts and our judges, and one of the most important things that the United States Supreme Court can do is to assure that judicial systems in this country are run properly and fairly. And so I do think the justices of this United States Supreme Court will be very interested in this case.
Okay, Mr. Olson, thank you for taking the time, and hope to talk to you again if this case is taken up by the Supreme Court.
Great. Thank you very much.